video, we're going to be covering conflict of laws for our highly tested MEE issues guide. So first things first, let's talk about frequency. And I also want to point out something that's unique about the subject of conflict of laws. So let's actually start with that. What is unique about this subject is that this is not a stand-alone subject. In fact, the National Conference of Bar Examiners, the people who write your exam, has explicitly stated that conflict of laws will not be tested by itself. To put this another way, this means that whenever you see a conflict of law issue, it's going to be tested with another subject. And in fact, conflict of laws is tested in a rather predictable way. It's usually tested with the subjects of civil procedure, family law, or wills, decedents, estates. And generally speaking, conflict of laws is not heavily tested. So while it's obviously fair game and you should never ignore it, it's not something that we would call heavily or frequently tested. So turning to the world of civil procedure and how conflict of laws is crossed over with Civ Pro. In terms of the frequency, this happens 50% of the time conflict of laws is tested. It will be tested in conjunction with Civ Pro. As it relates to conflict of laws being tested with family law, this is done 35% of the time conflict of laws is tested. And then as it relates to decedents' estates or wills, this is done 15% of the time. So 15% of the time you see conflict of laws tested, you'll see it crossed over with wills. So let's talk about those highly tested issues that they like to test when they do test conflict of laws. And first, let's talk about how they test it with civil procedure. So what they like to test here is what we call the Claxon Doctrine. So this is the idea that when you have a federal court hearing a case sitting in diversity, so to stop there, this means that the only way the parties got their case through the doors of federal court is based upon diversity jurisdiction. The parties are diverse from each other, meaning their citizenship is diverse at the time in which the lawsuit's filed, and the amount in controversy exceeds $75,000. In other words, they're not having some sort of federal issue heard by the federal court. So when a federal district court is sitting in diversity jurisdiction, they have to apply the conflict of law approach in the state in which it sits. So to give you an example, let's say a state law claim, specifically a New York state law claim, is brought in a federal court on diversity jurisdiction where the plaintiff is from New York and the defendant is from Washington. This means that that federal judge hearing the case will have to apply the choice of law approach or the conflict of law approach that a judge sitting in a New York state court would apply. The other way they like to test conflict of laws in the world of Civ Pro is when they test this in conjunction with transfer to a more appropriate forum. And they like to test transfer in conjunction to venue, which we know is relatively highly tested in terms of issues within the world of Civ Pro. So here, when they test transfer to a more appropriate forum, remember that this is a situation where a party has filed a lawsuit appropriately. In other words, their case is being heard in the correct court, but the court transfers it to another court that has the power to hear the case for the convenience of the parties or in the interests of justice. When this happens, oftentimes the question is, well, which law applies? The law of the transferor court or the law of the transferee court? And the answer is the law of the transferor court, or the law of the court in which the lawsuit was first and properly filed. If you struggle with this rule, I would urge you to think about the rationale behind the rule. This is really helpful in the world of civil procedure generally. If you can remember or try to think about why a rule is the way it is, it's more likely that you're going to remember the rule. So the rationale behind this rule is if a lawsuit's properly filed and it's just being transferred out of convenience, it doesn't make sense that we would apply a different law because we're transferring it. And in fact, that's incentivizing the parties to forum shop, which we don't want to do. So let's turn to how conflict of laws is tested in the world of family law. So they love to test this as it relates to the recognition of marriage. So the rule that you should familiarize yourself with here is a marriage that's valid under the law of the state in which it's entered into or contracted is also going to be deemed valid in other states so long as it doesn't violate a strong public policy of that other state. And they love to test the recognition of marriage as it relates to common law marriage. Essentially what they'll tell you is that the parties entered into a common law marriage and they move, or one of them moves, and they move to a state that doesn't recognize common law marriage. And oftentimes the question is essentially, well, are they married in that place that they move to? And the answer would be yes. Common law marriage, as a general rule, does not violate the public policy of any one place. To give you an example of things that are deemed to violate public policy are things like bigamous marriages or incestuous marriages. Those types of marriages would not be recognized because a state would have a good argument that those types of relationships violate their public policy. But common law marriages do not fall in that category. So if the parties are validly common law married in one state and they move to another state, even if that state does not specifically allow parties to become common law married, they still will recognize other people's marriages from a place where they did in fact allow a common law marriage. Now, turning to how they like to test conflict of laws with wills or decedent's estate, there's two rules that I want to point out, and it's all about the post-mortem distribution of property, and as it relates to both personal property and real property. So what we're talking about here is which state law will govern the distribution of your assets after you die. And the rule is different depending upon the type of property that we're dealing with. So as it relates to personal property, let's say like your clothes, for instance, the rule here says that your distribution of property will be governed by the state where the decedent was domiciled at the time of their death. So if you lived in Florida at the time you died, Florida law will determine the distribution of your personal assets. As it relates to your real property, if you own a farm or a piece of land, the rule is a little bit different. The law here says that it will be governed by the state in which the real property is located. So if you live in Florida at the time you die, but you own a farm in Michigan, Florida law will dictate how your personal assets are going to be divided, and Michigan law would dictate what happens to that farm in Michigan. Now, I want to leave you all with a tip as it relates to conflict of laws in the MEE. A big mistake that we see a lot of examinees make is they feel like they have to go into this long, kind of wordy, lengthy historical background about the conflict of laws if they see some sort of issue being tested. And we think the reason for this is that's oftentimes how conflict of laws is lectured on or taught by commercial bar prep courses or in law school. But just remember that that's not how it's tested on the bar exam. So our tip for you guys is to stick to the question being asked. The examiners don't really care about the long historical underpinnings or background. They want to know if you know the rule, they want you to apply it, and they want you to reach a conclusion. So remember that, and it'll in the long run save you time and get you those points. So that wraps up our discussion of those highly tested issues within the subject of conflict of laws.